And that Senator Cotter, given his considerable legal expertise, will address this issue much more deeply as part of his remarks. That said, the government certainly has concerns, and stakeholders have concerns, over how the private insurance industry will react to the introduction of the Canada Disability Benefit. And these concerns, colleagues, are not unfounded. The Minister of Employment, Workforce Development and Disability Inclusion is acutely aware about the potential for clawbacks and has committed to further engaging the private insurance sector once Bill C-22 is passed, to ensure that the benefit is understood as a poverty reduction measure meant to supplement existing disability benefits and supports. And that includes private disability insurance.
The government's goal is to work together with the private insurance industry and with other providers of existing benefits and supports to meet the primary goal of the Canada Disability Benefit, which is to reduce poverty and support the financial security of working-age Canadians with disabilities.
I'll now turn to Amendment Number 3, as proposed by Senator McPhedran, which is about the appeal process. The government has noted that this amendment makes some excellent points and most certainly strengthens the bill. What the government is now proposing is to build on that amendment and strengthen it even further. Bill C-22 does provide authority for the Governor and Council to make regulations respecting appeals. And now, with Amendment 3, the bill would also include an explicit right to appeal in legislation. Many stakeholders made clear the need for that during the parliamentary process. This amendment is aligned with the government's intention to provide a mechanism for appeals, but the phrasing of the Senate amendment can be understood as suggesting that a right to appeal the decisions would be immediate. Indeed, it could be construed as suggesting that the regulations could not require a person to first seek a review or reconsideration before appealing, and therefore the government is proposing that the wording of the amendment be clarified to be more specific and provide clearer details on the appeal provisions. For example, Amendment 3 lists 2 specific areas of appeal, which might raise doubts as to whether further grounds of appeal could be provided for by regulations. The government's amendment to Amendment 3 clarifies and strengthens the wording by widening the potential grounds of appeal as prescribed by regulations. Essentially, the updated amendment would make the appeals mechanisms for the Canada Disability Benefit more consistent with those of the old age security and unemployment insurance. In short, colleagues, the Canada Disability Benefit has the potential to make a real difference in the lives of working-age persons with disabilities and their families, and to reduce poverty in Canada. We can all agree that no person with a disability should be living in poverty in Canada.
Dear colleagues, the community of people with disabilities has contributed so much energy and emotion into this bill.
And recently held a rally on Parliament Hill to get this bill passed quickly. They're counting on us as we approach the finish line. But it isn't just Canadians with disabilities who are waiting to see us move forward with the benefit today. It's their families, it's their friends, and their advocates, people who understand their struggles. La grande majorité des Canadiens.
Canadians overwhelmingly agree that working-age individuals with disabilities need this benefit. We know this because, according to a 2021 Angus Reid survey, nearly 9 in 10 Canadians are in favour of the benefit. Our goal and their goal is to improve the lives of persons with disabilities.
Support the message from the other place so that we can bring this bill one step closer to implementation and ultimately royal assent. Je vous remercie.
Thank you.
Senator Dasko. Oh, I'm sorry. Senator Pay, do you have a question?
You take a question, Senator Gold?
Of course.
Great. Thank you, Senator Gold, and thank you for your comments. Last week, the minister referred to a detailed federal, provincial, territorial work plan that all jurisdictions have agreed to, and which will be the basis for formal negotiations respecting the Canada Disability Benefit. As you know, in the absence of the Senate's amendment prohibiting private insurance clawbacks, if the government is to meet its commitment to ensuring zero clawbacks, it will need to negotiate with 13 different jurisdictions, not only about interactions between the Canada Disability Benefit, their numerous government benefit programs, but also now about building prohibitions on clawbacks into provincial and territorial insurance legislation. Will you provide us with the work plan and timeline for these federal, provincial, territorial negotiations and clawbacks, and the role that people with disabilities will play in those, in that timeline and in that work plan?
Senator Gold?
Well, thank you for your question. And as you note, the negotiations with provinces and territories are being done with the involvement of the disability community. And these are, as you mentioned as well, a fairly large number of governments at stake, and of course, an important but still diverse communities of persons with disabilities. This work is underway. The minister has given her assurance of the good faith that she's encountering with provinces and territories. And as those discussions progress, I'm sure I have every confidence that Canadians will be updated as to their progress.
Senator Pate?
Madam Speaker. Many people with disabilities and organizations have reached out to us concerned that these negotiations will not be completed within the tight timeframes established by the bill. So I'm just curious if there's any information you can provide around the schedule, including the schedule for negotiating with insurance companies. Senator
Gold?
Well, I'm not aware. I do not have that information, but I am assured by the minister that they are proceeding diligently and seriously in these negotiations, and I think this chamber should have every confidence that the government is committed, as indeed are their partners in the provinces and territories, to conclude the negotiations in a timely fashion, so that finally these benefits can be provided to those millions and millions of Canadians in need.
Senator Daskal.
Thank you, Madam Speaker. I rise today to speak to the message sent back to us from the House of Commons concerning the fate of Bill C-22, which establishes the Canada Disability Benefit. This important bill seeks to reduce poverty and to support the financial security of working-age persons with disabilities through the disability benefit. Notably, C-22 is framework legislation whereby the details and elements of the benefit will be developed through regulations and in consultation with the disability community and with provinces and territories after the legislation is passed. We learned from testimony at our Social Affairs Committee, for example, from Krista Carr of Inclusion Canada, that 40% of Canadians with a disability live in poverty. And we also learned from the bill's sponsor, Senator Cotter, that 23% of those of working age live in poverty. Let's compare that to the 7.4% of all Canadians who lived in poverty in 2021, and we can understand the great need to take action. The bill had first reading in the other place a full year ago on June the 2nd and was sent to committee in the other place on October 18th. A total of 9 amendments were passed there before arriving here in February and at committee as of March 22nd. The bill arrived at our Social Affairs Committee with pleas from several major organizations representing those with disabilities and from the government to proceed without change. These pleas were accompanied by a very substantial email campaign carrying to us the same strong message. As committee work proceeded, it became clear, however, that the bill did indeed contain flaws and omissions, and as well, several strong advocates came forward to urge that these flaws and omissions must be addressed through amendments. Committee members were torn. Amendments or no amendments? Would amendments delay the benefit or even place the entire bill at risk? Colleagues, we often get admonitions to move quickly on legislation. This is not news to anyone. But I have to say that the pressure here to review this bill without change was especially strong. In the end, committee members did present amendments, and 6 amendments did pass committee, dealing with vital issues, including a specification that the benefit cannot be clawed back by insurance companies, a guarantee of an appeals process, a recognition that 4 additional factors, the additional costs associated with living with a disability, the challenges faced by those living with a disability and earning an income from work, intersectional needs, and Canada's international human rights obligations must be considered in establishing the benefit. An amendment to the preamble recognized that persons with disabilities may face additional barriers because of their gender, racialized or Indigenous status, or other intersecting statuses. And 2 amendments concerned the timeline and coming into force provisions. As we know, the government and the other place have accepted 5 of these 6 amendments. I'm deeply disappointed that the amendment designed to prohibit clawbacks of the benefit by insurance companies was not accepted. I felt it was a strong addition to the bill, but it was turned back for reasons related to jurisdiction that Senator Gold has just explained. So I won't try to go there. I am very pleased that the 5 other amendments were accepted, including an enhanced change to the amendment concerning the appeals process. I think that's a very positive change. Before closing, I want to mention 2 points that particularly caught my attention in the debate on C-22. In her 3rd reading speech, Senator Seidman drew our attention to Clause 12 of Bill C-22, which calls for a review of the Act after its 1st anniversary, 3rd anniversary, and at each 5th anniversary by a committee of the Senate, the House, or both. Senator Seidman further drew our attention to a recent article by Charlie Feldman, former parliamentary counsel for the Senate, which identified provisions in many federal statutes which call for review by Parliament. Mr. Feldman found 51 such provisions in legislation in the period from January 2001 to June of 2021. But he also discovered that many statutory reviews never happened, and others are many years behind schedule. Only 17 of the 51 had resulted in a report. Colleagues, I know we're not looking for more work to do, but it strikes me that vital and necessary work involving statutory review of legislation is not being done, and Parliament needs to step forward. A second point caught my attention as well, that being Senator Cotter's comment also at 3rd reading that an appeal process might be considered a matter of natural justice in legislation such as C-22, whether an appeal is stated in law or not. This is an extremely interesting and important observation, which for me raises questions about the circumstances and conditions in government or elsewhere where appeal processes might be available to complainants as a matter of natural justice. I look forward to hearing and learning more about this. These are considerations for another day, however, but I thank both colleagues for these interventions. Most importantly, the debate on C-22 allowed us to learn more about and to understand some of the real challenges of life, the needs and concerns faced by those who live with disabilities. I am grateful to all of our witnesses, to all of my Senate colleagues, and to the many, many folks who contacted me to express their views about the legislation before us. We have done some very good work, I feel, on C-22, and we in this chamber should be very proud of our contribution. And I urge acceptance of the message. Thank you, colleagues.
Senator Moody.
Madame la Présidente, honorable colleagues, I rise to continue our debate on C-22, and I really do want to thank my colleagues for their comments so far. Let me state from the outset that I will vote in favor of this message, fully respecting the prerogative of the government, and mostly because the disability community has made it clear that they're satisfied with this bill in its current form. But I want to take a few moments to highlight the important work done on this committee by the Standing Committee on Social Affairs, Science and Technology, of which I'm a member. Our chair, the Honourable Senator Umudvar, noted very clearly in her speech that at report stage, our committee heard 44 witnesses, in addition to receiving 48 briefs, 7 follow-ups, and 2 letters. And I want to add that many of our witnesses were members of the disability community and were given the accommodation needed to fully participate. Many of our witnesses were truly inspiring and went to extraordinary lengths to be with us, to be heard. And I'd like to thank these witnesses for their contribution to our study. Not only did we study this bill in depth, many of the committee members met on their own initiative with members of the disabled community for months before this study in anticipation of this bill's arrival and in acknowledgement of the historic nature and gravity of this bill. Our colleagues on the committee who worked diligently and with great insight and who understood that our job is to carry the voices and priorities of constituencies along with the application of our best judgment. So that is what we did. Our colleagues proposed amendments, some of which were rejected, many were adopted. And it was not easy. It was not an easy undertaking. It required the courage to resist the strong internal pressure to simply let this bill pass without amendments. Pressure to do nothing and to let the bill go through. Proposed amendments that we, as a committee, felt were needed based on what we heard from our witnesses. Amendments that the government has now, in essence, adopted. You have heard 5 of 6. As Minister Qualtrough put it in her speech in the other place on June the 14th, and I quote, "These amendments enhance Bill C-22 in that they add clarity, precision, and specificity." Close quote. Bill 22 is going to impact the lives of millions of people. It will be, putting hyperbole aside, the difference between life and death for many Canadians with disabilities. It will be historic, not just here in Canada, but on the world stage. And our contribution of clarity, precision, and specificity are absolutely critical. In fact, I'd argue that this is exactly why our institution exists, to make sure bills are precise, clear, and specific, for the good of all Canadians, including and especially for those who are vulnerable and who need us to work on their behalf and to bring their voice forward. So I want to congratulate our colleagues on the Social Affairs Committee for resisting the pressure to do nothing, for doing what you knew was right, despite the often repeated warning that it would kill the bill. Because, colleagues, in a few moments, we will adopt this bill, and it will become law. And it will be a better law, because we were unwilling to stand idly by, because we did our job. Colleagues, we have a privileged, sacred role to play in this place. The Senate has an obligation and a duty to review legislation. Fulfilling our constitutional role must always be front and center. Sometimes this can mean expediting bills. But I believe for the most part it means quite authoritatively, thoughtfully, deliberately, and thoroughly, we must consider every bill before us. Senators, that is how we should be, regardless of the pressure we may face to do otherwise. C-22 provides more Canadians will benefit when we are willing to do what we're summoned to do, to be legislators, to do our role. And this is what I believe Canadians value. And to the thousands of Canadians who continue to email us, urging us to adopt this legislation, continue to let us know and share their concerns. Thank you. It is my hope that we served you well. Like many of you, I was disappointed with the rejection of Amendment 2 and believe that the burden to fight to make sure clawbacks do not occur should not be on your back. Unfortunately, you may still retain that responsibility to ensure that you have full access to this benefit now. Nevertheless, what I've heard loud and clear is that you are ready to take the next steps and to make this benefit what you want it to be. I join with you in calling on the government to put this bill into force on the day it receives royal assent and to begin co-creation of regulation immediately. And should any issues come up, which there may be, you will find many of us here in the Senate of Canada behind you, ready to support you and to see that full potential of the Canada Disability Bill benefit is met. Thank you. Merci, Megwich.
Senator Petitclerc. Thank you, Madam Speaker. Honourable colleagues, the main points that had to be said about this Bill C-22 have already been said. Therefore, I will be brief. But I did strongly wish to speak to this bill today.
Senator Cutter for his work as sponsor of this bill in the Senate, and Senator Cutter for your commitment in the Senate and outside Parliament to persons living with disabilities. Colleagues, to this day, I remember the enthusiasm in the disability community when, in September 2020, the Canada Disability Benefit was announced in the speech from the throne. We knew then that the goal would be to reduce poverty and that it would be modeled after the Guaranteed Income Supplement for seniors. But we knew nothing about the amount of this future benefit, let alone the eligibility conditions. Nearly 3 years after, we are still a bit in the dark about who will be eligible or how much they will receive. However, it must be recognized that the enthusiasm and hope noted in 2020 is still strong and palpable. What I'm hearing is the community is reassured by the guarantees provided by the amendments made in the House and here in the Senate. Permettez-moi de souligner encore une...
Once again, I would like to highlight the work of my colleagues on the Social Affairs Committee and Technology Committee, who felt that these amendments, now accepted by the House through this response to our message, were necessary. Above all, I would like to thank all the organizations that inspired us and motivated us to improve this bill through their memoirs, testimonials, and correspondence. All in all, because of the work we chose to do, this bill has been improved and will serve better. Thanks to the Senate, the appeals process specifically provides for a procedure to deal with decisions made regarding eligibility for benefits and the amount to be received. Thanks to the Senate, in addition to taking into account the official poverty line, the benefit will have to consider several other parameters. including, among others, additional costs associated with living with a disability and the intersectional needs of disadvantaged individuals and groups. Thanks to the Senate, the government now has the power it requires to make the necessary regulations so that payments can begin within 12 months of the bill coming into force.
It's true, however, that concerns about clawbacks during implementation of the proposed benefit, especially by private insurers, have not gone away. The government has acknowledged that these fears are well-founded and has said it is aware of this risk. I am trying to be reassured by the minister's commitment that she will be vigilant to ensure that the concerns expressed during the study will not turn into a sad reality.
In an email sent to Quebec senators, Quebec organizations representing hundreds of thousands of people living with disabilities and their families, including the Quebec Society for Intellectual Disabilities, the Quebec Autism Federation, and the Quebec Federation of Organizations, Quebec Confederations of Organizations for People with Disabilities, shared the following message. To quote them, all but one of the amendments were adopted, and one amendment was the subject of a sub-amendment. From the outset, we are comfortable with the House motion. Of course, we would have preferred to have guarantees in the Act concerning insurance and the clawback, but the motion is satisfactory on the whole. End of quote. Messages from other national organizations, such as the Rick Hansen Foundation, the Canadian National Institute for the Blind, Inclusion Canada, and Disability Without Poverty all echoed the same tune. Now is the time, after the legislative stage, to take the next step to improve the financial insecurity in which hundreds of thousands of Canadians live. I agree with them.
I was tempted, by way of conclusion, to use the analogy that we are just about to cross the finish line with this bill. But I realize that it is not a right analogy, because really, this is not the finish line. C-22 being a framework law, it is fair to say that it is rather now that the work will begin. And so a better analogy would be one of a relay race. We gave it our best, and it's now our turn to confidently pass the baton, not just to the government, but especially to the ones with lived experience and expertise, to the organizations that were promised that they would be part of creating the regulations. These groups wanted their voice to be heard based on the principle of nothing about us without us. We can count on them, and I have confidence that they will carry out this duty with passion, with expertise, and rigor. La vraie ligne d'arrivée.
The real finish line will come when the first checks are delivered to beneficiaries, hopefully by 2024. I therefore invite you, dear colleagues, to pass on the baton by accepting this answer as we have received it from the House. Thank you.
Senator McPhedran.
Merci. Alors, bonjour, Tanzi.
Thank you.
Sénatrice du Manitoba, je reconnais.
As a senator from Manitoba, I acknowledge that I am on the traditional territory of the Anishinaabe, the Cree, the Ojibwe, the Dakota, the Dene, and the Métis Nation. I wish to state that the Canadian Parliament is situated on Algonquin territory, Anishinaabe, which is unceded and unsurrendered territory.
I rise today to speak to Bill C-22, the Canada Disability Benefit Act, with appreciation to Minister Qualtrough and the bill's sponsor here, Senator Cotter, for best efforts to shepherd it through the legislative process culminating in our review today. Many parliamentarians understand how crucial this bill is, long overdue and deserves support from millions of people with disabilities across Canada who live in poverty. We can be proud of the thorough and thoughtful contributions made by members of the Standing Senate Committee on Social Affairs, Science and Innovation, or SOCI, and of the trust placed in us by colleagues in this chamber in their support for these amendments, resulting in a stronger Bill C-22 returning to us today with all but one of our 6 amendments incorporated. The accepted amendments include an appeal mechanism by which applicants may contest decisions about their eligibility to receive the benefit and the amounts to which they are entitled. Also adopted was the expanded list of factors that must be considered in the benefit calculation, among which are Canada's poverty line, the costs created by systemic barriers to accessing work, the intersectional needs of applicants, and Canada's human rights obligations as they relate to the disability community. The final amendments accepted are those that provide for an expedited implementation timeline for the benefit by requiring that all the regulations must begin to pay out under the Act be in place within 12 months of the new Act's coming into force date. These changes bolster this Framework Act by ensuring crucial implementation mechanisms rather than risking them to the uncertainty of regulations yet to be drafted. Just one amendment has been rejected. I doubt Senator Gold intended to ghost me, but it was proposed by me on behalf of disability rights experts and organizations. Proposed for Clause 9C of the bill, this amendment would have protected recipients of the Canada Disability Act by preventing private insurance companies from deducting the amount of the benefit paid out under the Act from payments made under long-term disability policies. These clawbacks by private insurance providers were not discussed in committee in the other place, but they were studied extensively when Bill C-22 was examined by the Senate SOCI Committee. The amendment to stop rich insurance companies from clawing back the benefit from poor people with disabilities was endorsed by over 40 legal aid clinics, community leaders, academics, disability advocacy groups. On the question of its constitutionality, every provincial trial lawyers association in Canada supported the amendment as viable in law. And so, we have before us a bill that enables private insurance companies to claw back the new publicly funded disability benefit, regardless of whether Minister Qualtrough calls it a social benefit or not. Many private insurance contracts are clear that they can set off any government benefit, effectively subsidizing private insurers instead of providing additional financial support for members of the disability community as intended by the Act. Colleagues, concerns about industry clawbacks are not far-fetched or hypothetical. Clawbacks are happening now to available public benefits. Old age security benefits, for example, are already explicitly set off from long-term disability payments by many private insurance companies, while similar deductions have been made from insurance payouts to recipients of the dependent benefit under Canada Pension Plan. Further, the courts have sided with private insurers. For example, in a 2008 class action, the court affirmed the legality of deductions from long-term disability payments of this nature, absent any provision in either the policy or in the legislation prohibiting it. And private insurers leapt to enforce those deductions through litigation against disabled recipients. For example, in the case of State Farm Mutual Automobile Insurance Company, the appellant insurance company sought to enforce the deductibility of the CPP dependent benefit on the basis of the 2008 class action ruling. And in Industrial Alliance Insurance and Financial Services, Inc., the private insurers sought to enforce deductions from a long-term disability policy in the amount of benefits received by the policyholder under both the Canada Pension Plan and the Public Service Pension Plan. Time does not allow me to list the many other cases wherein private insurers went to court to claw back payouts under long-term disability policies premised on the policyholder's receipt of public benefits. The rejected amendment prohibiting clawbacks of the new benefit by private insurers would have done what the courts have said needed to be done in order to protect recipients, to ensure that benefits are received by those for whom they are intended, rather than function to subsidize private insurers. The time to respond to this concern is sooner rather than later. When the CPCP dependent benefit offset was challenged in 2008, industry relied on the fact that its premiums were adjusted on the assumption that it could offset CPP benefits, but held that without the availability of that offset, insurance premiums would undoubtedly rise. No such adjustment can presently be relied on by industry in relation to the Canada Disability Benefit, as premiums taking the new benefit into account have yet to be calculated. Concerns were raised at SOCI and in this place as to the constitutionality of a provision that engages with the insurance industry by purporting to regulate insurance contracting as falling outside the jurisdiction of the federal parliament. The fact is, such a provision is not unprecedented in Canadian benefit regimes. For 40 years, the Merchant Seaman Compensation Act, for example, has protected recipients with wording closely similar to that proposed in the rejected amendment. 40 years, honourable colleagues, with no court challenges, constitutional or otherwise. Another relevant precedent can be found in the 2020 reference Genetic Non-Discrimination Act, which grappled with the constitutionality of a federal legislative scheme to regulate aspects of insurance contracting by preventing private insurers from requiring genetic test results as a precondition for health insurance eligibility. In reviewing the legislative scheme, the court determined that its overall goal was not regulation of the insurance industry per se, but rather the prevention of genetic discrimination in the provision of goods and services, such that the insurance provisions at issue comprised only part of a broader regulatory scheme and were necessary in order to preserve the purpose of the federal legislation. Sound familiar? Absent the Act's protective insurance-related measures, the scheme's purpose would be seriously undermined, justifying the minor incursion into a matter traditionally falling within the ambit of provincial jurisdiction. These real-life cases support the viability of a provision like the rejected amendment, prohibiting set-offs by private insurers of payments under the Canada Disability Benefit Act. It is clear in the Act that the Canada Disability Benefit is designed to be supplementary for those who qualify under the Act. The legislative purpose of making a supplementary sum available to eligible recipients is undermined if private insurers are permitted to correspondingly claw back payments under their policies because, in practice, the recipient is left with substantially the same amount they were receiving before introduction of the benefit. Absent this simple operational protection, the bill before us today will effectively indemnify private insurers and deny the intended recipients the benefit. Lifting disabled people out of poverty is the stated fundamental purpose of this bill. And in this regard, it will become a mockery of Minister Qualtroux's promise to disabled people who desperately need and deserve the Canada Disability Benefit. The exclusion of this amendment to prohibit benefit clawbacks by private insurers is a choice the Trudeau government has made not to ensure that certain eligible recipients under the Act receive the full supplemental benefit promised to them. Time will tell how many private insurers will exploit this loophole given to them. And perhaps, someday, Parliament will have a second chance to bring justice to those disabled recipients who are now exposed to the legal force of rich private insurers. But let's not pretend that the real cost will be borne by poor, disabled recipients who will be made to suffer because this government chose not to protect them. They will suffer, and the cost will be borne by them. Last week, Senator Pate and I received a letter from Mr. Duncan Young, whose standard of living is determined largely by a private insurer. I share the following with his permission, and I quote, "I am not one of the many selfless volunteers who advocate on behalf of the disabled. Neither am I an activist or lobbyist for any such person or group. I am simply an average 55-year-old working-class Canadian who happens to love his job and is looking forward to working at it for as long as he can. Or at least I was. 3 years ago, I received a diagnosis of spinocerebellar ataxia 3, an extremely rare hereditary neurological disorder that causes the cerebellum to atrophy, thus completely destroying a person's motor skills, impairing walking, talking, swallowing, bladder control, etc. It is progressive, has no known treatments to abate its development, and there is no cure. Of note, an affected person typically does not present symptoms until somewhere between ages 40 to 55, meaning I, and most like me, are enjoying a full life still in its ascendancy when suddenly your brain will not allow your legs to form the motion necessary to let you run to catch the bus, or let your fingertips stay still long enough to do up the tiny buttons on your button-down collar. I'm continuing with the statement from Mr. Young. Let me be clear. Without that amendment enshrined in statute as worded, I will receive $0 from the creation of the benefit. It would be, in its entirety, an eligible clawback according to my limited provider's contract. In short, the only beneficiary of such a benefit would be the shareholders of a publicly traded insurance company, while I continue to slip below the poverty line. Both points here are not conjecture. They are quantitative facts. So you know exactly, unquestionably, and with detail, exactly what the passing of C-22 without this amendment will mean to myself and every disabled person in similar positions. Nothing. End of quote. I'm so sorry, Mr. Young. But at this stage, we must hope that Minister Qualtrough and this government can somehow turn this around by actively convincing provinces and territories to ban private insurance clawbacks of the CDB within their respective jurisdictional authority. Such advocacy should not be left, again, to the disability community to take on alone. Honourable colleagues, we all know this disability benefit is long overdue and desperately needed. The disability community in Canada has advocated for stronger and more reliable income support for far longer than this bill has been in contemplation by Parliament. I am grateful for the many insightful comments and valuable contributions to the development of this bill from community leaders and advocates, both in committee and in various other capacities. Mindful of time, I can acknowledge only a few, extending appreciation for the legal expertise provided by witnesses to SOCI who brought the clawback to our attention: David Lepofsky, Robert Latanzio, Stephen Muller, and Hart Schwartz. For the sake of those eligible recipients who are unlikely ever to see a penny of the Canada Disability Benefit, I fervently hope that these experts will continue to be vital contributors to the Minister's promised consultations to fill in the framework legislation. Let us now pass this bill into law before we leave for the summer. Thank you. Merci. Miigwech.
Senator Pate.
Thank you, Madam Speaker. Honourable Senators, Minister Qualtrough rightly called Bill C-22 a once-in-a-lifetime opportunity to lift people with disabilities out of poverty. Despite this tremendous step forward, the message from the other place risks turning this bill into an empty promise for Canadians who rely on long-term disability insurance. Our Senate amendment prohibiting clawbacks of the Canada Disability Benefit by private insurers would have protected the collective investment of Canadians in the well-being of the most marginalized from being diverted into the coffers of insurance companies. Our amendment put Canadians on the side of persons with disabilities, not wealthy corporations. The rejection of this amendment should leave us questioning, in whose interests did the government act? Would insurance companies actually dare take the money belonging to persons with disabilities that they rely on for necessities like food and shelter? The answer is yes, as acknowledged by both Minister Qualtrough and our Senate sponsor. Almost all group disability insurance policies and many individual policies allow insurers to deduct payments that the insured receives under any government-sponsored plan, as Senator McPhedran has just pointed out. Just one example that should be an affront to all of us is the clawback, again, that Senator McPhedran talked about by insurers of Canada Pension Plan payments from persons with disabilities, including the CPPD dependent portion earmarked for children of those with disabilities. Disability advocates have worked diligently to expose this issue. Imagine the advances towards eradicating child poverty if this money actually reached persons with disabilities. We have heard from some of the millions of Canadians to whom these types of policies apply. One working-class man wrote thanking us and urging us to persist. He has a hereditary degenerative condition that appeared later in life and incapacitated him. He was forced to leave his job. He needs the Canada Disability Benefit, should qualify for it, but may not receive an extra cent because of clawbacks. Without the Senate amendment, every penny of this man's Canada Disability Benefit may be stripped from him and pocketed by wealthy corporation. Yesterday, his daughter underwent tests to identify whether she has inherited the condition and the same fate. People may be even worse off if the Canada Disability Benefit application process is inaccessible. Insurance companies can actually reduce insurance payments if people are eligible for a benefit, even if they don't apply for it. How on earth can we support these kinds of windfalls for insurance companies? Do we really want to increase the profit margin of companies while leaving some people with disabilities even worse off than they would have been before Bill C-22, potentially receiving less from their insurers? Surely enriching wealthy insurance companies on the backs of people with disabilities and at taxpayers' expense is not what the government intended. Why then has it rejected our Senate amendment aimed at preventing this travesty? The government says it is concerned about infringing provincial and territorial constitutional jurisdiction. They propose to negotiate with each province and territory to change their respective insurance statutes, wait for these legislative changes to happen, and then negotiate individually with a large number of insurance companies not covered by these statutes. The first condition is that the larger legislative scheme This is in addition to the already significant negotiations planned with each province and territory to prevent clawbacks relating to all provincial and territorial government benefits. We should all be concerned there is no realistic way to accomplish this within the tight timelines for rollout of the benefit. Furthermore, countless practicing experts have provided compelling evidence that the Senate amendment is indeed constitutional. Rather than repeat the arguments that Senator McPhedran has already ably outlined, I will add 2 points. My first point is that, like Senator McPhedran, I've consulted with constitutional experts who have framed an arguable case in favor of constitutionality on the grounds of the necessary incidental or ancillary doctrine. This doctrine allows a provision situated within a larger legislative scheme to be pulled into validity if 2 conditions are met. The first condition is that the larger legislative scheme must be valid federal jurisdiction. I don't believe anyone has questioned the validity of Bill C-22. It is an exercise of the federal spending power and perhaps federal powers relating to peace, order, and good governance. The second condition is that even if the prohibition on private insurance clawbacks might be invalid if considered in isolation, it can still be valid if it has a necessary relationship to the larger scheme. Here, absent the Senate amendment, the benefit risks becoming a government subsidy for private insurance companies with no impact, or worse yet, negative impacts, such as the loss of additional provincial benefits like drug coverage, etc., on many disabled recipients. If that is not necessary to the Bill C-22 scheme, I cannot imagine what is. My second point is that, as you may remember, the Senate amended a government bill on solitary confinement based on testimony from legal experts that the legislation was unconstitutional. In fact, that vote passed 4 years ago today. The government rejected the Senate amendments, and the previous government representative explained to this chamber, and I quote, "Neither I nor anyone else in this chamber can substitute our conclusions for that of the justices who may be called upon to evaluate this provision at some point in the future. If there's one thing we know, it's that constitutional law is arguable, particularly in the abstract. The appropriate forum to resolve the issues with finality is the judicial branch. This is uniquely an environment where each litigant has a guaranteed procedural right to make a full case with the benefit of an exhausted evidentiary record before an impartial decision maker." End quote. I question why the government is not following this advice this time around. I hope it is not simply that the constitutional question concerns a Senate amendment rather than government legislation. There is a reasonable case in favor of the amendment's constitutionality. Knowing that the bill without the amendment amounts to an empty promise to a significant number of persons with disabilities, why doesn't the government accept the amendment and then see whether insurance companies have the gall to challenge its constitutionality in court? 4 years after the government stated that the courts were the appropriate forum for dealing with constitutional concerns about its solitary confinement legislation, the barriers that people with the least political, legal, and economic capital face when trying to defend their rights have thus far precluded a meaningful court challenge. Imagine trying to find legal assistance and mount a complex court case from a jail cell, while on the streets, while in pain, or while figuring out how to keep yourself and your family fed and sheltered. On top of this, the federal government may throw additional barriers to litigation in the way. For the solitary confinement legislation, the government had cases pending before the Supreme Court of Canada that would have given the court an opportunity to rule on its constitutionality. Instead, the government discontinued those appeals. Those seeking to challenge the bill now have to start from square one, meaning several costly, personally draining, and time-consuming hearings and appeals before they can hope to once again put this matter before the Supreme Court of Canada. With Bill C-22, the government representative has flipped the script, but the bill similarly favors those with the deepest pockets. This leaves marginalized and impoverished persons with disabilities with the unfair burden of going to court to seek the supports that the government has undertaken to provide. Why exactly is the government choosing to stand in the way of the most disadvantaged again? To grasp what the government's decision means very concretely, we need only look to a disability rights case litigated by Vince Calderhead, an internationally recognized human rights litigator. During his testimony on Bill C-22 at the Social Affairs Committee, he described a case commenced 11 years ago. It took a decade of court challenges for judges to determine that the Nova Scotia government had discriminated against his disabled clients, 2 of whom suffered irreparably but died, so they will never benefit from the legal win. Without our Senate clawback amendment, how many years will persons with disabilities have to wait to bring a similar challenge? How long will they endure poverty? How many will die in the interim? Here is the question. If someone must bear the burden of challenging government legislation, Should it be a private insurance company with deep pockets and ample legal resources? Or should it be an individual with a disability sufficiently impoverished to be eligible for the Canada Disability Benefit, yet unable to benefit from it? This is an urgent issue affecting real people, people with disabilities living in poverty, not merely an abstract legal conundrum. Do we want to clear the way for insurance companies to profit off the Canada Disability Benefit, or do we want to throw a lifeline to those abandoned to poverty and facing seemingly insurmountable odds in claiming their charter-protected equality rights? I do not say this lightly. I am painfully aware how urgently persons with disabilities struggling in poverty need relief. The Canada Disability Benefit, done right, should ensure that they have the necessities: food, shelter, medical products, care that breathe life into the human rights, in particular Section 15 equality rights and Section 7 rights to life, liberty and security of the person that Canada guarantees to all of us. Minister Qualtrough acknowledged that current inequalities exist because our systems, laws, policies and programs were not designed with or for people living with disabilities. We saw when debating medical assistance in dying that suffering is often not inherent to having a disability, but rather created by systemic exclusion and poverty. When MAID was expanded, the government promised to be vigilant in ensuring that no one was forced to choose death because they had not been provided with the supports they needed to live without suffering. The government has not lived up to that promise yet. As recently underscored by Ontario MPP Sarah Jama, people with disabilities from her community are applying for MAID because they cannot afford food. Living and working with persons with disabilities, I know both what a formidable burden disability communities are prepared to take on to hold the government to account, but also how wrong it is to offload onto them yet another fight for the Charter and human rights that most of us take for granted. Many of us are now extremely worried that some of the most marginalized persons with disabilities in Canada will spend years trying to fix our mistake. What do we want the legacy of the Senate's work on Bill C-22 to be? Persons with disabilities are contacting us daily, urging us to be brave and do what is right. These words, incidentally, were echoed last week by the Chief Justice of the Supreme Court of Canada at a swearing-in for new lawyers, including several who previously worked in our office on this very issue. Chief Justice Wagner reminded us to be brave and courageous and to stand up for what is right when others will not. Words by which to live and legislate, dear colleagues. Chi miigwech, merci, thank you.
Senator Bernard,
Madam Speaker, would Senator Pate take a question?
take a question. You have about 1 minute left.
Thank you. Senator Pate, in the other place, the government has taken the position that if the Senate amended prohibiting insurance clawbacks were included in Bill C-22 and challenged in court, this would, and I quote, create significant uncertainty and could impact the regulatory process, which could in turn impact benefit delivery. This could very well delay benefit payments, end quote. This type of court challenge might create some uncertainty about whether insurers can claw back the benefit, but it's difficult to see how it would create uncertainty about the issues that the government would need to determine in order to proceed with regulations and with paying out the benefit, such as who is entitled to the benefit, the amount of the benefit, and the application process. Senator Pate, do you have any reason to believe that benefit payments would be delayed in the event of a court challenge to the Senate's private insurance amendment?
Senator Pate?
No, none of, to my knowledge, and certainly our review of the testimony, no insurance companies indicated that they would plan to claw back the benefit. No provinces indicated that they would not support protecting the benefit.
Senator Cotter.
Thank you, Madam Speaker. I rise to speak to the message on Bill C-22. We are on the verge of a great achievement for tens of thousands of Canadians with disabilities. We've gotten to this point through the leadership of Minister Qualtrough, the determined work of people with disabilities and advocates for disabled people across this country, the commitment of every member of the other place at SOCI, and the commitment of every member in this Senate. And Senator's remarks today reinforce this. I urge you to accept the message without modification so that this bill can receive royal assent. First, I want to say, by way of context, in these remarks I'll speak only to the message that deleted the one Senate amendment related to the prohibition of clawbacks in insurance contracts, what I will call the No Clawbacks Amendment. The other amendments, in my view, are great. This one would be too if it were constitutional, and that's the point about which I will speak. We heard from many witnesses and senators about the valid and serious concerns regarding the potential clawbacks of insurance benefits, and I agree that all of these are legitimate and valid concerns, and I share them all. Unfortunately, for reasons I will explain, this is something that as a federal parliament we cannot address through legislation. If it were an arguable case, I would be for it. The purpose of these remarks is to give you some comfort that we are doing the right thing by accepting in the present form the message that's come to us. And in that regard, I note and applaud the statement of senators who strongly support the no clawbacks provision, but who have indicated that they will nevertheless vote in support of the bill in the form before us. Now, you've heard arguments in committee in this chamber why we can do this. I'm going to take a little bit of time to explain why we cannot. Not just as a competing opinion, but to a certainty that this provision is regrettably an unconstitutional intrusion into provincial jurisdiction. So a little bit about the Constitution of Canada, and I apologize for this sounding like a lecture. Though the clause is small, the point is significant. We know the Constitution is the supreme law of Canada. We are empowered by it and in some ways constrained by it. One of those constraints is federalism. As you will know well, in Canada, legislative authority is divided into two categories. Federal authority, or heads of power, nearly all of which are enumerated in Section 91 of the Constitution Act. The provincial authority in Section 92. The key provincial one, relevant to our discussion, is property and civil rights within the province, which is universally understood to include the regulation of contracts in the province. And parenthetically, virtually every aspect of the insurance sector has been ruled by our highest court to be of provincial jurisdiction. We don't think very much about this next point, but everything we do in the Parliament of Canada has to be located in one area or other of federal jurisdiction. So if it's a matter of related to Section 91, Ottawa has free rein to regulate. If it's Section 92, provinces rule. Two examples of Section 91 authority that you know well, banks and banking, for one. In this head of power, Ottawa gets to set the rules. This includes regulating contracts under this power. Contracts concerning banks, minimum wages, employment standards for bank employees under the banking power. Another is criminal law. If something is genuinely criminal, Ottawa can prohibit it, including contracts. Just this week we will do this by making loans above a certain rate of interest. Contracts to provide loans, a crime, again under the criminal law power. Next, the spending power. There is a federal spending power. The spending power is not listed in Section 91. It is based on the idea that Ottawa has property, in this case money, and can do with it as it pleases. This is true within limits I will explain. It is a powerful but limited federal authority. All are agreed with respect to this legislation that it resides within the federal spending power and only within the federal spending power. The question we are facing is whether the no clawbacks provision is a constitutional use in the exercise of the spending power. I should just say parenthetically that despite Senator Pate's observation about ancillary provisions, ancillary powers do not apply to the spending power, and for obvious reasons I will get to. At committee and in this chamber, 3 arguments were advanced to justify the constitutionality of the no clawbacks clause. Each of these is 100% incorrect. The first was the reference to the Merchant Seamen's Compensation Act. This federal statute has a similar no clawbacks provision, which has never been constitutionally challenged. But the reason the Merchant Seamen's Compensation Act provision has not been challenged is it's not an exercise of Ottawa's spending power. Indeed, it has nothing to do with the spending power at all. It is an exercise of Ottawa's Section 91 head of power over navigation and shipping, a Section 91 power specifically. You only have to read a little bit of this bill to discover this. And just like banking has a specific head of power given to Ottawa, Ottawa can regulate entirely in that area, including, just like banking, it can regulate contracts. The second argument, to the effect that Ottawa can regulate contracts, was the Supreme Court of Canada decision regarding the constitutionality of the Genetic Non-Discrimination Act, which dealt with contracts and was upheld by the Supreme Court of Canada. But when you read this case, you discover that what Ottawa does in this context, for example, with respect to the examples Senator McPhedran identified about one example being requiring employees to take genetic testing, Ottawa invalidated those contracts by making them a crime. And if it is legitimately a crime, Ottawa has the power to regulate, that is, prohibit contracts under the criminal law power. Indeed, but for the finding that Ottawa was exercising its criminal law power in those cases, the provisions would have been profoundly unconstitutional interferences with property and civil rights. Furthermore, and this is important, just because Ottawa can regulate or prohibit contracts in one specific area, this does not make that authority transferable to another area, and in particular not transferable to the spending power. And there are very good reasons, sadly, for that. So the third spending power argument was a quote from a distinguished, now deceased Professor Peter Hogg, the Dean of Constitutional Law in Canada. This is what the quote said. Parliament, speaking about the spending power now, may spend or lend its funds for any government or to any government or institution or individual it chooses for any purposes it chooses, and it may attach conditions to that grant or loan. Now, Professor Hogg had a bit more to say about the spending power, and in the sentences that follow that quote, they explain what the limits of the spending power are. There is a distinction, said Professor Hogg, in my view, between compulsory regulation, think here the no clawbacks provision, which can obviously be accomplished only within the limits of legislative power, and spending or lending or contracting, which imposes no obligations on recipients. There is no compelling reason to confine spending or lending within the limits of legislative power, meaning Ottawa can go where it wants with its spending, and it does, as you know, because in those functions, it's not purporting to exercise any peculiarly legislative authority over its subjects. That is, people can take the money or not. There's no legislative power engaged. What this means is that in spending its money, Ottawa can spend in areas of provincial jurisdiction and can impose any conditions it likes on the recipient of the money, but it cannot use its legislative power to impose obligations on anyone else, obligations that are in provincial jurisdiction. To be sure of this, I read every case Professor Hogg cited, and all of them confirm this. The bottom line is that Ottawa can attach conditions to the receipt of money by the recipient, but it can't go beyond that. Think of it like a pipeline down which money can flow. Ottawa can attach terms and conditions to the flow of that money, If the terms are not met, it can cut off the flow, it can require money to flow back, but it can't legislate outside the walls of the pipeline. So let me suggest for you an example of the most significant use of the spending power in this country, and a compelling example of its limits. Funding to support health care. Ottawa transfers billions of dollars to the provinces to support the delivery of Medicare under provincial jurisdiction. It does this in the exercise of the spending power, and it attaches conditions to the transfer of the money. You know it well, particularly the 5 principles of the Canada Health Act. One of the most obvious concerns is that Ottawa does not want doctors to extra bill patients for insured services under Medicare. You've heard this a million times. If, as is argued, the spending power is essentially unlimited, the most obvious way to achieve this would be for Ottawa to transfer the money and then simply legislate that doctors can't extra bill. I hope you can see the parallel. But Ottawa does not do this. A condition of the health transfer is that doctors aren't allowed to extra bill, but that obligation is imposed by the provinces. The prohibition against extra billing in every province in this country is done by provincial legislation. Not because Ottawa wouldn't want to do it, by God they would, but because constitutionally they can't. And it's the same with the no clawbacks provision. It would be great to do it, but we can't. Just because it's a very good idea doesn't make it constitutional. Section 91 does not have a head of power called good ideas. Now, this is a small provision, but constitutionally, the overall issue is enormous, quite frankly. If Ottawa can, through the use of the spending power, wade into provincial jurisdiction whenever and wherever it wants to spend money, as the proponents of this provision would have it, it would actually be destructive of federalism. Senator Platt spoke a while ago about the attention we need to pay to regional interests. I'd invite you to focus for a moment on provincial interests and our duty to be respectful of provincial jurisdiction on which those interests rest. There is likely to be litigation if this clause were implemented, and here's an awkward, tragic dilemma. The provinces, even sympathetic to the intentions of this clause, would have to join with insurance companies to avoid an unprecedented expansion of spending power into provincial jurisdiction. Whether we like it or not, and I don't, the no clawbacks clause has within it the seeds of an almighty constitutional fight, which Ottawa would assuredly lose. To say nothing of the way in which it would poison federal-provincial relations, just at a time when Fed-Prov cooperation in the delivery of this benefit is at its most crucial. Some have suggested that declining to include the no clawbacks provision by the government and 314 members of Parliament twice is being done in deference to the insurance industry. I would invite you to think of it in a different way. It's actually an expression of respect for the provincial jurisdiction at play here, a statement that honors provinces, and a signal to desire to work with them rather than against their interests. Indeed, this approach increases the possibility, mentioned here earlier, that provinces will exercise their own jurisdiction to protect this benefit by disallowing insurance clawbacks, and it increases the prospect of working out protocols with industry whereby the disability benefit will not result in clawbacks. I'm not happy with that outcome. I am as concerned about the stories that you have heard, that I have heard, as anybody, but there are limits to what we can do. Indeed, we have an obligation to respect those limits, whether we like it or not. I hope and trust that this will give you some degree of comfort that in adopting the message as received, we are doing the right thing. And as we now have the opportunity to launch this bill and its great, great benefits for our most deserving citizens. Thank you. Merci.
Are senators ready for the question? It was moved by the Honourable. Is it your pleasure, Honourable Senators, to adopt the motion? Carried. Adopté.
As ordered earlier this day, second reading of Bill C51